Hello, everyone, and thanks for joining us at the second day of International Law Weekend 2021. I'm Conway Blake, counsel at Debevoise and Plimpton, and I want to extend a very warm welcome to you for joining us on this panel in which we'll be addressing the issue of recent challenges which face the framework for diplomatic and consular immunities. Today, I'm joined by a panel of very distinguished speakers who will be joining me in conversation to explore the various challenges that are now being faced in this area of the law. As we know, the area of immunities law is one of the oldest roots of branches of international law. It dates back to the days of the Greeks and the Romans. And it is a fundamental aspect of how international relations is organized. The efforts to codify the law on diplomatic relations and immunities came to a head and found its real traction in 1961 in the conclusion of the Diplomatic Relations Convention of that date. It's one of the most widely ratified conventions with over 190 ratifications. That convention lays down a number of very fundamental aspects of the law of immunities, in particular, the principles of the inviolability of the diplomatic mission, also the inviolability of the diplomatic agent, and immunities from suit, both criminal and to certain aspects of civil jurisdiction. And while diplomats and diplomatic agents carry on their business every day without incidents, we've all become aware of incidents of what are perceived abuses of immunities. Certainly, if the media is to be believed, the law of diplomatic immunities, it gives rise to what may be perceived as a law that allows global elites to live in a lawless zone and in a law unto themselves. We have a number of anecdotes from various jurisdictions where you could think about law. And so today, we wanted to reflect on what has been achieved in this area of the law, this very fundamental area of the law, to think about the legitimacy of it, and to think about the ways in which we can ensure, or we can ensure that this area of the law is fit for purpose in contemporary international relations. To help me think about and to talk about these issues, I'm joined by a panel of 4 distinguished ladies. I'm joined by Professor Philippa Webb, Professor of International Law at King's College London. She's also a barrister and practitioner here in London, an expert on diplomatic immunities, and having litigated the issue, including with members of my firm in the English courts, all the way up to the Supreme Court. Thank you very much for joining me today, Philippa. I'm also joined by Professor Laurie Damrosch. Laurie is the Hamilton Fish Professor of International Law and Diplomacy at Columbia University. And prior to commencing her career in academia, Laurie served in the US Department of State's Office for the Legal Advisor, during which time she worked on the seminal case of the Tehran hostages before the ICJ. I'm also going to be joined, or I'm joined today by another member, a present member of the US State Department, Miss Vanessa York, and she's an attorney in the Office of the Legal Advisor of the US Department of State, with special emphasis on issues of immunities, and she'll be giving us a sense of US practice and the practicalities and the nuts and bolts of immunities. And last but not least, I'm joined by Professor Concepcion Escobar Hernandez, who since 2012 has been the ILC Special Rapporteur on the subject of immunity of state officials and criminal jurisdiction. She's also a professor of public international law at the Universidad Nacional de Educación de Distancia. I'm really honored to have you all here today with me. We're hoping to have each speaker give a very brief set of comments on areas of of immunities. We're going to be looking at both practice in the United Kingdom, practice and comparative practice in the United States, and then thinking about locating, with the help of Concepcion, diplomatic practice much more broadly in other areas of immunity. And so we're going to start with Philippa in the United Kingdom. And I must say before you start, Philippa, that we're hoping to have a very active discussion. Please do send questions in the chat box, and we'll be posing questions after the end of the substantive comments. Thank you very much. Philippa, please go.
Thank you, Conway. It is striking that an ancient principle, as you've pointed out, Conway, with a long history, that was designed to protect rulers and their envoys from insults to their dignity, is applied by our courts today with only fairly minor modifications. Diplomatic immunity is invoked in cases that may shock our conscience, but the heinous nature of the allegations is not a justification for lifting immunity. So I'm going to focus on law in the United Kingdom, as Conway said, and an interesting feature of English law, which is not shared by the United States, for example, is that cases involving current and former heads of state also raise issues of diplomatic immunity. And that's because under Section 20 of our State Immunity Act, it states that subject to any necessary modifications, the Diplomatic Privileges Act, which incorporates the Vienna Convention, applies to a head of state as it applies to an ambassador. But it's not so easy to draw an analogy between a diplomat posted in a receiving state and a head of state who may only occasionally come to the UK on an official visit. It's also not clear what that mysterious phrase necessary modifications means. And this led the House of Lords in Pinochet number 3 to observe that it is hard to resist the suspicion that something has gone wrong in the drafting of the UK's legislation. But that's what we have and what we have to apply. So I'm going to briefly address 3 points drawn from recent English case law. First, that immunity does remain a strong bar to jurisdiction in cases involving diplomats. Second, that there are challenges within the diplomatic law framework, and one is the potential for an evolutionary interpretation of existing exceptions to immunity. And third, that another route is through emphasizing the functional purpose of immunities. And these are all drawn from cases over the last 4 to 5 years. So the first point, that it is still a strong bar to jurisdiction. And just to give you a sense of some of the cases that involve very serious allegations. So in one recent case, a local authority sought care orders over 3 children aged 4 to 14 years old, whose father was a diplomat. And it was alleged that the parents had lashed the children with a belt and forced them to kneel or balance for hours in painful positions. So the 3 exceptions to immunity in Article 31 did not apply on these alleged facts. This was nothing to do with a movable property or with succession or with a commercial activity. So the local authority in that case argued that a new exception should be read into the convention for applications to protect children or vulnerable adults at risk within the diplomat's family. Well, the court rejected that argument and upheld the immunity of the father. It explained that it would violate the natural meaning of the words in Article 31 to add a new exception to the list, that there must be global uniformity as to the meaning of the convention. And if a tacit exception was to be made based on safeguarding children, then other states may assert that children of British diplomats are at risk based on differing cultural and moral standards. And the court concluded that the fact that diplomatic immunity may sometimes be abused is a price which has to be paid to uphold the higher principle of ensuring peaceable relations between states. And of course, the court pointed out that it was always possible for the Secretary of State to ask the sending state to waive immunity or, as a last resort, to declare the diplomat persona non grata. In another case, there was an allegation of torture by an Egyptian general who came to the UK on a special mission. And once again, the court found that immunity would be upheld, and there was no conflict between the UK's obligations under the Torture Convention and its obligations to respect special missions immunity, especially, it said, the core immunity from criminal proceedings. And we also have the high-profile claim against Anne Sakoulas for the wrongful death of Harry Dunn. As you know, I'm sure from the news, her car collided with his motorbike when she was apparently driving on the wrong side of the road. And in a judicial review of the decision by the Foreign Office to say that she has immunity and allow her return to the United States without being charged, the court took a strict interpretation. They said that although her husband, who was actually employed by the US government in the UK, only had immunity for his official acts, according to an exchange of notes between the UK and the US, no provision had been made for the spouses, family members of such staff. So she continued to enjoy absolute immunity from criminal proceedings, and therefore they found that nothing had gone wrong in their judicial review. So my second point is that the use of an existing exception to immunity may create more success for claimants or victims. And the most promising exception in this regard is Article 31(1)(c), which is a professional or commercial activity outside the diplomat's functions. So just earlier this month in the UK Supreme Court, this exception was argued in a case, and I represent the claimant, so I'll just report on what's been said in the public domain. So a Saudi diplomat is alleged to have trafficked a Filipino domestic servant to work in his home in assumed conditions of modern slavery for nearly 2 years before she was able to escape. And proceeding on these assumed facts, because we're at a preliminary stage, the question is whether that conduct constitutes a commercial activity. It's already been held in a previous case that such conduct is outside a diplomat's official functions. But what remains to be decided in a binding way in the UK is whether these allegations of human trafficking bring it within the commercial activity exception. And unlike the earlier child abuse case I mentioned, the claimant is not asking the court to unilaterally amend the Vienna Convention or develop a new exception. Instead, she's asking the court to interpret commercial activity, recognizing the evolution in what our society considers to be commercial. And in another case, the professional activity aspect of the Article 31 exception has been interpreted to allow service of process on a sitting president, with the commercial court finding there was a good arguable case that seeking contributions to a political campaign was a professional activity of a politician and therefore not immune. So my final point is that courts are also paying careful attention to the functional rationale for diplomatic immunity. It is not mere lip service in the fourth recital to the Vienna Convention, which says that immunities are not to benefit the individuals, but to ensure the efficient performance of the functions of the diplomatic mission as representing states. And this played a role recently in a case holding that the Prime Minister of the United Arab Emirates is not immune from civil proceedings relating to private matters, in that case, proceedings regarding the welfare of 2 children. So the English court in that case has separated out the head of state, the head of government, and the Minister of Foreign Affairs, the traditional troika, and found that they don't have identical immunities. And in fact, the head of government only enjoys functional immunity from civil jurisdiction. But this will only go so far because the functional basis is still a very broad basis. And in another case, a former head of state was found to be immune from claims arising out of the nationalization of a bank. The alleged conduct, which was a conspiracy that he strongly denied, would have been done in his public capacity as president, even if the acts were for a private or improper purpose. So this provision in international law that when you act under color of authority, you still fall within the functional realm, gives a broad scope to the definition of the performance of functions and the entitlement to immunity. I look forward to our discussion.
Thank you very much, Philippa. I just wondered if you would just answer just a question that I have, an observation I have. Interesting, we're seeing what seems to be a clash of international norms. I wonder if in the cases to do with children, whether there was an invocation of the Convention on the Rights of the Child, and whether there were arguments similar to the arguments about the clash between the Torture Convention and the diplomatic immunities regime, whether those sort of fragmentation, clash of regime arguments were made.
Yes, they were. So in the case involving the alleged child abuse, the local authority invoked the Torture Convention, actually saying that the alleged treatment of the children that had to be assumed at that stage amounted to torture, and brought in the UN Convention on the Rights of the Child, and also brought in the European Convention in Section 3 of the Human Rights Act, and tried to argue for a human rights-oriented interpretation of the Vienna Convention that would read in this child protection exception. So that was part of the argument, and it was once again, soundly rejected by the court on the basis that you would anticipate, which is the procedural substantive distinction. We may have these substantive obligations to prevent and punish torture, to act in the best interests of the child, but we have this procedural obligation to uphold immunity, and that prevailed.
Very, very interesting. I'm sure we'll have a further conversation on these decisions. Moving now swiftly stateside, I want to welcome Laurie with her presentation. Thanks, Laurie.
Sorry, I have to unmute myself here. So thanks very much. Thanks for your gracious introduction. And I'm very pleased to follow Professor Philippa Webb, who is indeed one of the leading authorities on immunity law worldwide, not only in the United Kingdom, on which she has focused with the current cases, but really with global perspective. She's given us this tour d'horizon of the very recent cases. And I want to go back really to the first principles, not as far back as Conway suggested in going back to the Greeks and Romans, but going back to the Vienna Convention, the Vienna Convention on Diplomatic Relations, which, as our moderator has said, is one of the most widely ratified international treaties. It has, as of today, 193 states parties, and there are 181 for the Vienna Convention on Consular Relations. And the principles underlying these treaties, which I think we need to underscore as a matter of first principles, do remain among the most important for the successful functioning of diplomatic and consular relations. Now, our moderator introduced me by mentioning that when I served in the State Department, I was immersed in these issues for a time, beginning on November 4th, 1979, for the application of the Vienna Convention on Diplomatic Relations, Consular Relations, and two other treaties when US diplomatic and consular staff were taken hostage in Tehran and held for 444 days. And I worked on the pleadings in that case, which involved many interesting questions of diplomatic law, including the remedial dimension. And I think it's important to underscore the policies underlying these rules of diplomatic immunities, even when the host state alleges that the diplomatic or consular officers have abused their privileges and immunities. The ICJ, in its merits decision in the case concerning diplomatic and consular staff in Tehran, said, quote, "There is no more fundamental prerequisite for the conduct of relations between states than the inviolability of diplomatic envoys and embassies, so that throughout history, nations of all creeds and cultures have observed reciprocal obligations for that purpose." The court continued that the institution of diplomacy and diplomatic relations has proved to be, quote, "an instrument essential for effective cooperation in the international community, and for enabling states, irrespective of their differing constitutional and social systems, to achieve mutual understanding and to resolve their differences by peaceful means. Now, the court added that when the legal principles of immunity and inviolability of diplomats are attacked, those attacks, quote, cannot fail to undermine the edifice of law carefully constructed by mankind over a period of centuries, the maintenance of which is vital for the security and well-being of the complex international community of the present day, to which it is more essential than ever that the rules developed to ensure the ordered progress of relations between its members should be constantly and scrupulously respected. Now, when the two conventions, the 1961 and 63 conventions on diplomatic and consular relations, were developed, their drafters and negotiators did appreciate and anticipate that serious criminal acts could well be committed. Intentional killings are rare. Accidental deaths are much more common. Traffic deaths are probably among the most common, and the Ann Sakulis case, to which Philippa Webb made reference, is one of the more notorious recent instances of a tragic traffic accident. When someone dies, that tests the limits of this framework. But even so, as the ICJ underscored in the Tehran hostages case, diplomatic officers cannot be arrested, detained, tried, or obliged to give evidence under any circumstances. Consular officers enjoy a lesser degree of immunity from criminal process. They can be brought under criminal process for instances of a grave crime and pursuant to a decision by the competent judicial authority, but that's not so with diplomatic officers. And in the case of the Tehran hostages, the receiving state was threatening to put the diplomatic and consular officers on trial for acts which it said were in violation of local criminal law and which were an abuse of the privileges and immunities of the diplomatic and consular staff. And what the ICJ said about that was that the Iranian threats to submit diplomatic personnel to trial on any charges or to compel them to bear witness, quote, would constitute a grave breach by Iran of its obligations under Article 31 of the Vienna Convention on Diplomatic Relations. This is still the law, and I submit that it is still good law. Now, the ICJ said that in the event of crimes or other abuses of privileges and immunities, the receiving state has remedies. Professor Webb alluded to them. There is the remedy of declaring the offending diplomat or diplomats persona non grata and requiring them to leave the country. There's the even more extreme remedy of severing diplomatic relations with the sending state. If those extraordinary remedies are exercised, the diplomat must at all times be given sufficient opportunity to leave the country, and that sort of grace period applies even if armed conflict breaks out between the sending state and the receiving state. The ICJ considered that what it called this self-contained regime of diplomatic law is entirely efficacious. We can debate whether it is entirely efficacious, but that was the term that they used. They did acknowledge a brief exception that a diplomatic agent caught in the act of committing an assault or another offense might be briefly arrested by the police of the receiving state in order to prevent the commission of the particular crime. But apart from this preventive exception, the remedies for abuse of privileges and immunities are found in the Vienna Convention itself, namely declaring persona non grata or severing diplomatic relations. They're not found within the ordinary criminal law, even if the crimes are very severe ones. Now, as the panelists preceding and following have discussed and will discuss, recent challenges are highlighting demands for possibly reframing the regime that we have. Maybe there are more egregious abuses of privileges and immunities than the framers of these conventions contemplated, though I doubt it. And admittedly, some host states are taking umbrage when persons who are shielded by diplomatic or consular privileges and immunities behave in ways that sending states interpret as interference in their internal affairs. Now, the Vienna Conventions do allow persons enjoying privileges and immunities to obtain by lawful means information about developments within the receiving state, but sometimes their information gathering activities are interpreted as violative of local law, or as insulting to the host state, or as interference in the host state's internal affairs. The most recent instance that we have comes this week. It was reported in the New York Times on Tuesday of this week that in an incident apparently resolved on Monday, Turkey had taken umbrage that 10 ambassadors from NATO countries had called upon Turkey to comply with a judgment of the European Court of Human Rights in the case of opposition figure in Turkey, and someone who's been held without charges for 4 years, or without conviction in any case. And this demand on the part of the diplomats from 10 different countries was sufficiently irritating to Turkey that there was a threat that Turkey would require them to leave the country. That matter seems to have been successfully resolved by a recital in parallel by the 10 states that they're in compliance with the Vienna Convention. So what underlies this regime of diplomatic and consular law is, first of all, consent on the part of the receiving state to receive the diplomats, and second, reciprocity, that all states are both sending and receiving states. All states open up diplomatic or consular relations on a reciprocal basis with other states. And in order for the system to work, it has to be understood that whatever we do must apply as a general rule on a reciprocal basis with all the states with which we engage. Now, when disputes arise, we have the possibility already alluded to that disputes can be peacefully settled through invocation of an optional protocol to the Vienna Convention on Diplomatic Relations, and also to the Vienna Convention on Consular Relations, as the United States successfully sought in the Tehran hostages case. Both of those optional protocols have been invoked quite a number of times. I'm sorry to say that the United States has withdrawn its acceptance of both of those optional protocols, and not a very large number of states have accepted them. I think it's about 70 for the Diplomatic Relations Convention and about 50 for the Consular Relations one, or vice versa. In any case, it is also possible for disputes to be resolved on the basis of an ad hoc consent, so that the ICJ has heard some cases involving disputes over the application of diplomatic privileges and immunities on the basis of consent given on an ad hoc basis. Now, the previous speaker made reference to some differences between the legal framework in the United Kingdom and the legal framework in the United States. And I'd like to say just a couple of words about that. There are certain individuals whose status under US law is not clear. The head of state who visits the United States, or the head of government, or the foreign minister, or someone who comes on a special mission for a particular time-limited purpose, there is not the same sort of international treaty or the same sort of statutory recognition of the immunities of such persons, and therefore one needs to develop much more elusive arguments about the customary international law of such persons when they are visiting in the United States. I had my first exposure to those issues when Prince Charles made a visit to the United States during my time in the State Department, and he got sued with process in a case that came to be known as Kilroy versus Windsor. And it was a question whether the executive branch could recognize the immunity of the Prince of Wales when there wasn't anything in either treaty law or statutory law that conferred on the Prince of Wales any level of diplomatic, consular, or other immunities. I did research on the special missions problem, as to which there is a treaty, but it's not anywhere near as widely ratified as the treaties we've just referred to, and therefore its evidentiary value as customary international law is more precarious. We had a number of cases in the United States in which it was alleged that persons who had acted under the authority of a foreign state, such as a former defense minister who was alleged to have been involved in war crimes, torture, and crimes against humanity, he ended up in the United States, and there were questions about whether the Foreign Sovereign Immunities Act would cover an individual who had held office formerly in a foreign state. And the Supreme Court about 10 years ago in a case called Samantar versus Youssef held that the Foreign Sovereign Immunities Act does not cover individuals acting on behalf of a foreign state. I think our moderator is intervening to tell me that my time is just about up. So I'm just going to make a nod in the direction of a theme that I hope we can explore further in the question period. It picks up on one of the points that Professor Webb mentioned, which is the possibility that courts could or perhaps should apply an evolutionary approach to immunities law so that the laws of immunity might contract as our appreciation of other values such as human rights law or the need for accountability or the need to overcome impunity might be growing. And while I personally share a very strong desire and a jurisprudential philosophy that would accommodate such an evolutionary approach, I fear that the US courts in their current configuration with the US Supreme Court on the jurisprudential trajectory that it has been on for some time is not very likely to welcome an evolutionary approach. I can say more about it if time permits in the question period, but the most recent negative indication that we have comes in the foreign state immunity area, foreign sovereign immunity, a case that was decided earlier this year involving Holocaust era claims, a case called Federal Republic of Germany versus Philip. And the Supreme Court essentially said, we freeze the Foreign Sovereign Immunities Act in 1976, and taking in violation of international law does not allow us to import modern conceptions of human rights law. It doesn't even allow us to consider genocide or torture or the most heinous crimes unless Congress has given us a specific legislative instruction to do so, which the court did not find in that sovereign immunity case. So I have more to say on evolutionary interpretation, but I'll save it for a later point in the panel. Thank you.
Thanks so much, Laurie. Very fascinating. Hopefully we can explore how that fits into the broader sort of interpretive approach of the US Supreme Court. And as non-US lawyers look at, the obsession with original intent and the idea that international law is frozen in time and doesn't evolve. And that's obviously an argument that is also mirrored in international law, including in relation to evolutionary interpretations of treaties. Fascinating, but we must go on as time is limited. So I want to invite Vanessa to address us.
Yeah, hello. So I'm going to talk about really sort of four things. Sort of one, things that Professor Webb and Damrosch have touched upon, sort of why diplomatic immunity exists. Try to sort of limit my remarks there since it's already been covered to some extent. Then talk about sort of limits that are both already built into the framework. And I will focus on the VCDR, but it's important to sort of distinguish between the VCDR and VCTR because they're very different in that regard in terms of the scope of immunity that applies. Then a little bit about US practice, how we deal in reality with circumstances where there are incidents in the United States involving foreign diplomats and then incidents involving US diplomats serving overseas. And then that sort of flows into sort of consequences, right? Sort of even if there's particularly in the context of a criminal case, if immunity is not waived, what happens next and what can still happen in those instances? And then a few concluding remarks. So on this topic of why diplomatic immunity exists, Professor Webb mentioned that the preambular language in the VCDR, the purpose of diplomatic privileges and immunities is not to benefit the individuals, but to ensure the efficient performance of the function of diplomatic missions as representing states. And so in the drafting of the VCDR, the ILC's Special Rapporteur's report talks about different theories for why diplomatic immunity exists. The extraterritorial theory, whereby the embassy is somehow on the other state's territory, that is largely discounted, except for in popular imagination and TV series. The embassy is still on the territory of the state, of the receiving state, and the laws of the receiving state apply. The representational character theory, which has made it actually into the preambular language, but whereby sort of the diplomat as the agent of the state. But then really, I think what is the best explanation is the functional necessity theory. We need diplomatic immunity to enable DIPs to do their jobs. And so Sir Gerald Fitzmaurice said at the time, it is impossible for diplomatic agents to carry out his functions unless accorded certain diplomatic privileges and immunities. And so diplomats around the world continue to do important work in relations between the states. And even in circumstances where relations are not friendly or even hostile. Diplomats are the messengers for messengers that are unpopular to the receiving state, including on human rights issues. And they're engaging with democratic opposition movements in authoritarian states. And to some extent, possibly even, sort of reporting on those. So in those circumstances, immunities exist primarily to prevent a receiving state from instituting or threatening to institute judicial proceedings against a diplomat or his or her family member to silence the diplomat or to exert undue pressure on him or her. And immunity from jurisdiction-only official acts is insufficient because diplomats could easily be falsely accused in those circumstances. So that is sort of why really fundamentally diplomatic immunity exists, why it's important. Then, to shift gears a little bit to what are sort of some of the built-in limits on diplomatic immunity and consular immunity. For one, I think most people don't realize most of the comprehensive immunities that a diplomat, someone at an embassy, enjoys end when they leave their assignment. So residual immunity, so-called residual immunity, only applies for acts performed in the exercise of diplomatic functions. So anything personal, that can come back and they can be prosecuted, or civil cases can be brought against them for their personal acts. So that's one important factor. Two, of course, sort of there's different categories of embassy staff. Diplomatic agents versus administrative and technical staff of an embassy. The latter and their family members do not enjoy immunities in civil cases in non-official matters. So they don't have the full comprehensive protection in civil cases, with the exceptions that Professor Webb had already mentioned. Relatedly, the VCDR for consular relations provides a far more limited scope of immunities, and consular officers and consular employees, those assigned at the consulates, do not enjoy immunity from jurisdiction, either criminal or civil or administrative, under the VCDR for personal matters. It only covers acts performed in the exercise of consular functions. Here, I should note that the United States has negotiated bilateral agreements that are, plus up the level of immunities for consular staff. And you can imagine, for instance, that one was negotiated with the former Soviet Union for the reasons explained, that there's a sense that immunity only for official acts can be insufficient in certain circumstances to allow the mission functions to function. But that absence of bilateral agreement, that's what the VCDR provides. So then in terms of practice, there are certain recognized, I don't want to call them exceptions, but sort of an understanding that there are limits, I guess, to the immunities that are provided. So one, and they sort of relate to some extent sort of principles that of sovereignty or a nation of sort of that states can take actions in order to protect public safety or the safety of individuals. So, for instance, police could prevent a diplomat in the active commission of a crime and sort of stop that crime. This might come up with alleged drunk driving. Police can literally detain and stop the diplomat if they believe that the diplomat is engaged and continues to engage in is drunk at the time, and they only need to hold him for the duration of the time to prevent someone else to pick him up, but they can stop that conduct. Diplomats, it's pretty well recognized that diplomats are expected to pay routine traffic ticket, routine parking citations. There's a mixed practice on, so for instance, breathalyzer tests. So diplomats have personal availability, and there's to some extent diplomats might consent to a breathalyzer test. The practice on sort of parking tickets and traffic citations that don't require court appearance, that one could argue that also applies in the context of sort of COVID measures that are needed for public safety. So for instance, when there are lockdowns and a diplomat violated rules regard to lockdowns, that type of ticket they would be expected to pay, arguably. And then there's sort of steps that states have taken in practice to make sure, particularly in the driving situation, which is the one that comes up the most frequently. So for instance, the State Department's Office of Foreign Missions has a program whereby it issues this driver's license and points and suspends driver's license for foreign diplomats if there is an issue. Professor Webb talked about sort of child issues, and that's of course a very, very serious concern. And so one of the ways to potentially navigate that is to focus on things that child protective services can do to counsel family members, to on the basis of consent, to make sure that that might not reach the most serious cases, but sort of if there are concerns, to work with family members short of sort of law enforcement actions. In terms of US practice, both overseas and then in the United States, basically what happens is if there are allegations against a foreign diplomat in the United States, then a prosecutor tells the State Department, I would prosecute this individual for a crime, but for immunity. The United States will ask for a waiver of immunity. If the sending state does not waive immunity and it is a serious crime, the entire family has to leave. And in some cases, in some of the most serious cases, that might not seem like a harsh result, but in some of the cases that is a pretty significant consequence for the family that is concerned. Working on this, I realized that you don't want to commit a crime in Virginia. So things like shoplifting, and in case might involve 3 T-shirts from an expensive department store, it can be charged as a felony in Virginia, and if it's a felony, it would be a basis to send someone home. Reciprocally, the United States often, and I think Professor Damrosch touched upon testimonial immunity, and so the United States frequently waives testimonial immunity or archival inviolability in order to facilitate proceedings in the host government where information from our diplomats would facilitate that proceeding. Though the standard in personal cases versus official cases is generally either it has to meet a standard of being essential to protecting US government interest or the individual consent. So there is a presumption against waiver in personal matters if the individual does not consent, though ultimately that is a policy decision that's made on a case-by-case basis. So I realize I'm coming up on time. I wanted to quickly talk about what happens if there's a criminal case and the sending state does not waive immunity. Does that mean that there's no consequence? And that's not quite the case, right? So both Professor Webb and Damroff mentioned PNG, persona non grata. That might influence someone's career. If you're sort of sent home, that's, there's some consequence to being declared persona non grata. There's a possibility of civil cases against A&T staff members, even while they're assigned there. I mentioned that residual immunity does not apply. So a case can be brought after the diplomat goes back home, the assignment ends. If, as long as you are able to serve them, you can certainly bring that case. There are also receiving states might impose limitations on travel. So under the Immigration and Nationality Act, there's a provision that if someone in the short, right, has been accused of the crime and the state asserted immunity, that person cannot return back to the United States unless to face prosecution. So that can, again, like it might not be a result in every case, but at least that person is not going back to Disneyland without facing prosecution. And then finally, right, in certain cases, there could be discipline by the sending state and prosecution by the home state, and that we do see that happen. That does occur. Depending on the circumstances, they're both sort of sometimes prosecution in the United States or prosecution in a foreign state where the foreign state has told us we're not going to waive immunity but prosecute. So I'm realizing this is my time is up. So I will to wrap this up, I will just say the beauty, right, of the VCDRs is that it's really a framework that existed for hundreds of years, and it's a good one in striking a balance between first encouraging appropriate behavior by diplomats, and sending states should remind their diplomatic corps of the duty to respect local law under the VCDR. Secondly, it does provide some tools, limits, and remedies if diplomats do not behave badly. And then just finally, really enabling the functions of the diplomatic missions in representing states in an increasingly interconnected world in which the work that our diplomats do reduce and help avoid conflicts, may promote human rights and democracy, protect nationals in the sending states, economic and cultural exchanges between states, and so much more. Thank you very much.
Thank you very much, Vanessa. That's a very interesting summary of the actual practice of using other means to mitigate what could otherwise be seen as the strictures of immunity, including, for example, the use of family services to intervene in the case of children, and trying to get to a substantive result using the consent of the diplomat rather than the force of the criminal law. Interesting ideas, interesting thoughts for us to continue to discuss after our final presentation by Concepcion, which I'd like to have begin now. So Concepcion, if you would address us, that'd be great. Thanks.
Okay, thank you very much, Conway. Well, I think that my intervention will follow a different approach than the presentation from the previous panelists, because I intend focus on the works of the ILC on immunity of a state official from foreign criminal jurisdiction, and the possibility to establish any relationship with diplomatic and consular immunities. As you know, the ILC started with this topic in 2007, and now likely we could be able to finish next year in the first reading. The purpose of the draft articles at the ILC is to establish a kind of the general legal regime. And for that reason, I would like to mention draft article 1, paragraph 2, that yet adopted by the Commission, which read as follows: the present draft articles are without prejudice to the immunity from criminal jurisdiction enjoyed under special rules of international law, in particular by persons connected with diplomatic missions, consular posts, and others. If we look at this provision, we could conclude that the International Law Commission draft articles on immunity of state officials as a general legal regime is not applicable to diplomats and consuls. But such a conclusion, must be nuanced for different reasons. I would like to mention some of them. First of all, I would like to recall that diplomatic immunities applies only to diplomats posted overseas and only with respect to the authorities of the receiving states. Second, full diplomatic immunities. If we want to, we can say the personal immunities, so immunity ratione personae, established under Vienna Convention only apply during the term of office of the diplomatic agent. Third, the Vienna Convention established also that after the end of the term of the diplomat, immunities remain only with regard the official acts, but without determining the legal regime applicable to that remaining immunity. And fourth, in accordance to draft Article 2, paragraph F, E, adopted until now by the Commission, and I quote, "State official means any individual who represents the state or who exercise state functions." So I think that from that perspective, it is obvious that diplomats and consuls in case are state officials. I would like to say finally that ILC draft articles on immunity of a state official from foreign criminal jurisdiction intend to set up a general regime applicable when no special regime is applicable, but the relationship between the legal regime and the special regime is based on the structure of the without prejudice clause, what means that it is possible to establish some kind of relationship between those both regimes. Well, having that in mind, I think that it is possible to think about two different scenarios where the rules contained in the ILC draft articles could be applied in connection with diplomatic and consular immunities, in particular with regard to diplomatic immunities. The first is the first scenario when a third state, other than the receiving state, intend to exercise its criminal jurisdiction against a diplomatic agent or a consul. And second, when the receiving state intend to exercise criminal jurisdiction against a former diplomatic agent. In the two scenarios, we can consider the applicability of both diplomatic immunity and a more ILC general regime. In the first one, diplomatic immunity regime is not applicable to the authorities of the third state, but the issue of diplomatic immunity could arise in the context of a request for mutual legal assistance, in particular an extradition request addressed to the receiving state. And in that case, the third state will be regarding immunity from a general perspective. Instead, the receiving state will look at immunity from the perspective of the diplomatic immunity, In the second scenario, Article 39, paragraph 2 of the Vienna Convention applies, but it could be possible to take into account and apply several rules and procedures contained in the ILC draft articles. At any rate, it is clear that in both scenarios, the domestic authorities concerned will probably consider the issue of the determination of immunity from the perspective of the immunity ratione materia. For that reason, I would like to make some comments about the general regime of immunity ratione materia as it is nowadays in the project of the International Law Commission. I would like to say that the ILC has made a clear distinction between immunity ratione personae and immunity ratione materia. I will not make any reference to immunity ratione materia, because even if Professor Webb make some comments about the treatment of the head of state in the UK on the basis of the domestic law, is not a general rule or a general practice, the application of the norms of diplomatic immunities to head of state. Well, I think that the most important with regard to the work of the immunity, the work of the ILC on immunity of state officials from the perspective of the immunity ratione materia, is that the Commission has tried to identify the normative elements of this kind of immunities. And all the normative elements included in draft Article 5, 6, and 7 of the draft articles are related directly with the functional character of immunity, and second, the need for establish a balance between immunities, general rules applying to immunities, and other values of international law, in particular human rights, or more clearly the fight against crimes under international law. Well, the first normative element is contained in draft Article 5, and according to that, this draft article, immunity applies to state officials acting as such. I would like to put the emphasis on acting as such, because this expression has been included by the Commission in order to strengthen the functional dimension of immunity. The second element is contained in draft Article 6, and determining the scope of immunity ratione materia. The three elements are being taken into account. First, the act covered by immunity, only the acts performed in an official capacity. Second, the continuity of immunity, even in case when the individual concerned have ceased to be state officials. And third, safeguard clause that allow to make a bridge between immunity ratione personae and immunity ratione materia. In accordance with this last element, individuals who enjoyed immunity ratione personae, whose term of office has come to an end, continue to enjoy immunity with respect to acts performed in an official capacity during such term of office. This last element is, I think, is very important with regard to the status, the applicability of the draft articles to the immunity of state officials, in particular to the diplomats. But I would like in particular to call your attention on draft Article 7. In accordance to draft Article 7, immunity ratione materia from the exercise of foreign criminal jurisdiction shall not apply in respect of the following crimes under international law: crime of genocide, crimes against humanity, war crimes, crime of apartheid, torture, and enforced disappearance. Probably draft Article 7 is the most controversial draft article adopted until now by the ILC in the context of this project. But the purpose of these draft articles is to make a balance between the protection of values of international law, others than immunity, or others than sovereignty and stability of international relations. Second, the purpose of the draft Article 7 is to make a bridge between the main rules existing in international law, devoted to the definition of international crimes and in order to set up an international criminal system, if you let me say, use this word. I think that this draft article is a guarantee for avoid the possibility to make a confusion between immunity and impunity. I will finish in a second, sorry. And at any rate, I think that the inclusion of these three elements, the three normative elements, could be very interesting for states, even when they are working on diplomatic immunities before national and domestic courts, and only a message, probably we could talk after in the question and answer. I think that this one of the most interesting part of the project of the Commission is the proposals of new procedural and safeguard rules that could allow a state to build confidence conditions and to objectivize and despoliticize the relationships with regard to immunities. I thank you so much, and I'm sorry for having to speak too much.
No, that's fine. Thank you so much, Concepcion. And I think your presentation brings us neatly to where we probably want to end up, because the presentation about what the ILC is doing sees a different type of framework. Laurie talked about the ICJ decision in the hostages case, starting from the premise that the present diplomatic immunities framework is efficacious, that it's self-contained and it strikes the right balance. But obviously the ILC's debates on immunities in a different context show that the balance or the factors that are being taken into account in terms of how different values are balanced may have shifted. And we see that in the litigation in the United Kingdom, with litigants trying to invoke human rights norms, peremptory norms, the norm against torture, to strike a new balance and to mitigate what may seem to be the strictures of the functionalist approach. I wondered if I could bring Philippa back to talk a little bit about what we see in the UK, what appears to be a quite rigid approach to immunities, a very unnuanced sort of reliance on the functionalism. Perhaps maybe the international system of international relations wouldn't collapse if there were some tweaks to the balance, perhaps.
Well, I fully agree on the need for tweaks and rebalancing. I think arguments that try to create a new exception, to read in a tacit exception, to reinvent the wheel to that extent are destined to fail. But I do have hope for arguments, and building on what Professor Damrosch said, that take an evolutionary approach. And that evolutionary approach is not just to look at the way our economies are run, the way our societies are organized today, as opposed to in 1961 or even earlier, but also to bring in other relevant rules of international law applicable between the parties. And so it will be interesting to see what the UK Supreme Court does in this pending case on whether human trafficking falls within the commercial activity exception to diplomatic immunity, because the framework for that argument is accepting the rigid approach of the English court, saying we're not trying to create a new exception, but trying to bring in an evolutionary interpretation. And we don't have the same judicial culture of focusing on original intent that we see in the United States. So I do see some hope there, but it's definitely a matter of watch this space.
No, I've been looking very keenly. I think the problem, however, is I think the language of commercial activity isn't limited to one piece of legislation. It might open up the door in other legislation which seek to use that same sort of commercial as opposed to other exceptions. So there might be some pushback from the court on the basis that we're doing some violence to the notion of commercial activities. But I'm sure it was very well argued, and we look forward to receiving and seeing what the court says on that. Laurie, I wondered if you could come back in. You emphatically said that, you know, the statement of the law in Tehran hostages is correct as a matter of law, and echoed the notion of the regime being efficacious. And I wonder whether you think that the levers that are offered in the convention, namely persona non grata and severance of diplomatic relations, whether that is sufficient, or aren't those blunt tools in the wide variety of instances that we might see of you know, crimes that are committed or serious affronts to the legal order in the receiving state.
They're very blunt instruments, and I don't want to embrace everything that the ICJ said about those tools being completely efficacious, because I actually think that we should move beyond in some certain respects. What I wanted to underscore was just that the policies underlying the substantive norms of diplomatic and consular law are still valid, but this remedial dimension could use some strengthening, so that when privileges and immunities are abused, or when crimes are committed that are going unpunished, there would be alternative means, not by dismantling the regime, but by working perhaps along the lines that Professor Webb has suggested, to make a somewhat more creative use of some of the exceptions that find a plausible textual on other basis. And it's in that context that I just want to comment on this jurisprudential question of evolutionary interpretation. And although I favor it, I'm just very skeptical that our courts are going to be very creative about doing that. You invited me to say a few words about the different interpretive philosophies that the US courts use. And of course, for constitutional law, we have this very strong tendency toward glorifying or sanctifying the original intent. And unfortunately, some of those same ideas bleed over into a very restrictive approach to customary international law, sometimes to statutory interpretation and to treaty interpretation. So I gave one example in my opening remarks, and there are others. I think the one that's actually the most interesting has to do with immunities of international organizations. So there we had a 1945 statute. It said that the personnel of international organizations will get, quote, the same immunities as are enjoyed by foreign governments. And clearly, Congress in 1945, having had little to no experience with international organizations, just wanted to take off the shelf some body of law that might have seemed sensible in 1945. And we had problems starting from 1945, traffic tickets or traffic accidents resulting in injury and death, and many other problems involving commercial and other activities. And then the question, which the Supreme Court decided 2 years ago in a case called JAM versus International Finance Corporation, was whether we take the same immunities regime as it existed in 1945 and freeze it for all time, or if the immunities of foreign governments have changed over time, do the immunities of international organizations and their personnel shift accordingly? And there, interestingly, the Supreme Court was willing, through techniques of domestic statutory interpretation, to bring into the international organizations immunities regime the more restrictive approaches that had already considerably narrowed foreign sovereign immunity and other branches of immunities laws. So that's one perhaps harbinger, but unfortunately in the cases involving the construction of the law of nations under the Alien Tort Statute and some cases of treaty interpretation, we see a much more constricted approach. I see my time is.
So I wondered if we were to reconstitute this area of law from a present point of view, from where we stand now in international law, rather than harking back to the functional arguments of days old. Whether a balance could be struck, as Concepcion suggested, with the notion of diplomatic agents not having immunity for grave crimes. Now, one member on the audience noted, though, that the notion of grave crimes could be abused by the receiving state, right? Because it becomes perhaps the arbiter of what a grave crime is. And Vanessa spoke about the possibility of a hostile receiving state, concocting charges and basically using the threat of criminal prosecution to impose pressure on a diplomatic agent. Concepcion, do you see the possibility of a type of grave crime exception still being abused and still undermining the fundamental functionalist rationale for the regime of immunity?
Yeah, I said that my reference to draft Article 7 and the crimes under international law is made with regard to the general regime. That means that one former diplomat could be prosecuted, or the state could try to prosecute a former diplomat on the basis of that draft articles, or on the basis of of these crimes. Of course, I think that the risk of abuse exists. The risk of abuse exists. I think that it is impossible to say that no state will use the accusation of the indictment on having committed, for example, torture, in order not to put pressure on a diplomat or on the state of the diplomat. But for that reason, we have decided to introduce some procedural safeguards. I think that if I consider that the immunities of state officials continue to be a legitimate regime. Of course, there are no doubt about the usefulness of this kind of instrument, but at the same time, we have to make a balance with values, the protection of values of international law, and also the protection of the foreign states with regard to its own sovereignty, because the right to exercise jurisdiction is a part of the sovereignty and is protected by the principle of sovereignty. But I think that the only possibility to guarantee or to strengthen in a certain way the possibility not to use the crimes against humanity as a way for politicize the justice and for politicize the exercise of jurisdiction is to introduce procedural rules and procedural safeguards. For that reason, I think that that part of the work of the Commission is the most innovative and the most important, at least for me, but I think that also for other members of the Commission. Thank you.
I think that's very interesting, the use of procedural safeguards to mitigate against the risk of abuse. Vanessa, I was very interested in your discussion about the various ways in which the United States uses a sort of ad hoc and bilateral approach to mitigate the strictures of the immunities regime. I wonder, though, whether the success of that has much more to do with American power in international relations, and whether smaller states that are less powerful have a less powerful bargaining power would be able to use as many tools, and whether for their sake the blanket rule isn't the best thing, or whether you think that it's these levers are available to many states who could negotiate them, or whether this is just a reflection of America's power on the international stage and its ability to dictate the basis on which diplomats are received.
So I think that sort of some of the tools, I guess, I talked about in terms of just, parking ticket, traffic ticket, those are well established. It's also well established, for instance, that everybody is subject to routine security screenings at an airport when on a departing flight. Similarly, I think that sort of there are these measures of not exercising jurisdiction, not using law enforcement authorities, and I think that that's available to everyone. The PNG is certainly a tool that is available to all states. Available. I wanted to shift gears for a minute and just sort of talk about sort of this evolution and how it applies. And I think that there's a distinction in that regard between foreign sovereign immunity and diplomatic immunity, right? In the foreign sovereign immunity context, we're talking by and large a customary international law that has not been reflected in any treaty basis, whereas there's a UN convention, but it's not been ratified or is not in force. And as but in the diplomatic law context, right, the states are not only bound by or sort of have their own implementation of the laws, but they still have the treaty obligation, and the treaty basis is going to be interpreted based on the rules of treaty interpretation, including the plain meaning and the negotiating history between the parties at the time of the treaty. And so in that regard, particularly with regard to Article 31 and the exceptions for commercial and professional activity, in fact, the negotiating history makes pretty clear that the drafters of the convention are looking at that provision in relation to Article 42 of the VCDR, commercial and professional activity, and really thinking of in the context of, the diplomat has a side or outside job. And that is by and large my understanding of how US courts have looked at the Article 31C exception as well.
That's a great point. No matter how inventive we might want to be in relation to our implementing statutes, we still have the convention, which really dictates the state's international obligation in this sphere. I'm really, really sad to have to wrap up, because I think this has been a really fascinating discussion, a lot of really interesting insights. I want to thank the panelists, Professor Webb, Damrosch, Professor Escobar Hernandez, and Vanessa York. Thank you so much. It's been a very fascinating and informative discussion. There's a lot of food for thought. I think what comes out of this discussion is a fundamental recognition of the need for an immunities regime in the context of diplomatic and consular relations. However, recognizing that as notions of what legitimate expectations receiving states might have of diplomats and what their international obligations are, and continue, and as those international obligations continue to evolve, the way we view immunity will be challenged. And it's going to be interesting to see how, through law development, whether it's in the courts or whether in the ILC, or whether perhaps a revision to a treaty, these problems and these balances will evolve over time. Thank you very much. And I wish everyone a good rest of the day and enjoy the rest of ILW 2021.